So that happened. This is a renewal of a mistrial motion brought by Corinne Ruff Mull, who did not disappoint. She's tenacious. Remember, she brought this mistrial motion yesterday when we learned about the Atlanta Journal-Constitution reporter who had approached a juror and had some sort of interaction. The judge investigated, denied the motion. The motion was renewed this morning with some extra flavor, and she apparently had done some investigation, and we learned a little more about the interaction. It seems it maybe was a pleasantry initiated by the reporter, just saying, "How's it going?" which was interpreted by the juror as something more important, like, "How are you guys doing, and when do you think you'll be done?" And then, according to the information presented this morning, when the reporter came out of a restaurant, it was the juror approached her and kind of offered further information, at which point she walked away. But today, Joseph Scott Morgan, we're hearing a little more about a broad complaint that the defense counsel has. Don't forget that she did not want this trial streamed live as we're doing on Law&Crime Network. They objected to it from the beginning. So now it seems to me, Joseph, that this incident yesterday with the Atlanta Journal-Constitution reporter has given her a kind of a wedge to drive some other issues home to this court in the form of another mistrial motion. You know, even talking about our colleague Ashley Wilcott. She can't possibly have an opinion because she's a judge. I don't know. What are your thoughts on this whole mishmash this morning? Okay, sounds like we're having a little technical difficulty. Oh, wait, I just heard something there. Do we have you, Joseph?
Okay, I'm back.
Okay, go ahead.
Yeah. Hey, listen. She's doing her job. You know, as a defense attorney, and she's trying to take this idea that from the tiny acorn the mighty oak grows. And you know, with the reporter in the courtroom, first off, the reporter should have been admonished. These individuals have no business speaking to a jury. Period. And so that's within the realm of acceptability to admonish that juror. I don't know that it's grounds for a mistrial. However, moving forward, she appears to have really dug in her heels here, and we'll see how this plays out. Now, if this case goes forward, which, you know, more than likely it will, and it comes up for appeal in the event that they are found guilty, this is going to make maybe a basis for an appeal. We'll see what happens.
There's no doubt about it. And we heard at the very end of the judge's instruction there that he did deny the motion that was just brought this morning. He's denied that. We are moving on. The newest wrinkle is now they want to sequester the jury during the deliberations. They've been at it about 16 hours, so they're going to get a bite to eat. They're going to corral them and give them a chance, just like the Amato jury, to go get their jammies and toothbrushes. And for the balance of the deliberations, it sounds like they will be sequestered. Let me read a quick note that the reporter involved in this case wrote to the court. Quote, "Please accept my sincerest apologies for causing unnecessary drama in the courtroom today," meaning yesterday. "I was simply exchanging pleasantries with this man. He talked much more to me than he let on in court. Regardless, I feel awful about ever opening my mouth. I take my work seriously. I would never want to disrupt the judicial process," end quote. So her mea culpa may have further incited defense counsel, maybe given them a little further urging, since she admitted in writing what happened. She had already told the court what happened. The juror already told the court what happened. And now the court is suggesting, as a remedy, removing this juror from the panel. What do you think about that, Joseph?
Wow, I don't know. I would be interested to see if the judge would seriously take that under advisement. But as to defense counsel's motion, you know, this is akin to stepping on flypaper. The more you wiggle around, the more stuck you'll become. The reporter, you're right, in acknowledging this, writing the note, open the door even further. Defense is going to try to probe this as deeply as they possibly can because they are simply doing their job.
Yeah, and we know that you can just see the signposts for the appeal. We're going to take a quick break, all of that unfolding in real time. Glad we could bring that to you, and the judge didn't pull the plug on us. This is the Law&Crime Network. We'll be back in just a moment. Well, that was not exactly what was expected. We know the judge was thinking about removing juror number 76, the one that's been involved in this contact with the Atlanta Journal-Constitution reporter. Now he's moved that juror to alt status. Now, in some jurisdictions, the alternates take part in all of the deliberations, and that way, if there's a swap out at some point, you don't have to start over. Well, obviously, that's not the case here in this Georgia courtroom, because The judge just told this jury, who's been at it for 16 plus hours now, hey, nice practice, because now you're going to have to start all over because juror number 95 is being swapped into the 12-panel mix and will now begin to deliberate this case all over again. Joseph Scott Morgan, thoughts on this little wrinkle?
Hey, listen, I'm having a hard time kind of wrapping my mind around this idea that that 76 would be going to alt status, because if they're to the point where they're tainted in some way, if something else happens, how can you put them back in? I just don't understand that.
Here's my thinking on that.
In a pristine state. So
yeah, I get you, and I appreciate that. Here's my thinking on this, and maybe a kind of a midway step toward potential sequestration. If he is an alternate and part of the sequestration, he is at least sanitized from presenting any of the information he learned in deliberations to the world, which I guess is a possibility based on why we're talking about this right now. That's my only thought, is that rather than release him and let him be out and about with what he may know, let's keep him in the mix. That's my best guess.
Yeah, and I hope that they'll keep a very tight rein on the jury. Obviously, if they're going to go into sequestration, then that's the idea. I can only imagine. Hey, this has been a long journey for these jurors. Let's keep in mind they've been at this now for a while, and to have this happen at this moment in time, I'm wondering if this is going to change, or it will change. I'm wondering how much it will change the dynamic of the jury. Going back into the room, and I'm sure that there'll be some level of frustration because they've heard all of this. That now they have to rehash this again, and it's going to be interesting to see which road they go down, and we may never know how it will change the dynamic, but it certainly makes for interesting copy.
Oh boy, you're right. It is fascinating. I would love to talk to some of these jurors afterwards. Let's go back into court right now. It sounds like we just caught the end of that little conversation between the court and the attorneys. It sounds like he was basically telling them not to contact anybody. Some normal kind of admonitions that he would make before a recess. He seemed a little consternated. Joseph Scott Morgan, do you detect the same thing I did with the judge, that he's a little frazzled by this? It's not a good move.
Yeah, I'm sure he is. Listen, being a judge in a situation like this, he's got multiple balls in the air here that he's having to maintain order. He's thinking about the decisions that have been made prior to court relative to allowing coverage in the court. He's thinking about, evidentiary concerns, these witnesses, and to boot the jury, ultimately he's the defender of the jury. He's the protector of the jury. And this is his group of people that he's trying to keep as pure as possible going forward. I kind of alluded to this idea yesterday with, we were talking about this contact that the member of the press had. It's almost, put it in a medical context, it's almost as if, you walk into you're an observer in a surgical suite, and you walk in and, ungloved and unmasked, and you stick your hands into an open surgical wound. It's that dangerous. You're messing around with fire. So I can imagine he is pretty upset at this moment in time.
Yeah, contamination, that's a good analogy. So Joseph Scott Morgan, hang around. We're going to be following the developments in this case. Maybe the jury will be sequestered in Georgia versus Jennifer and Joseph Rosenbaum. Maybe not, but at this point they are adopting their new family member. An alternate has been moved from the alt status onto the main panel in this jury. And the gentleman, juror number 76, has been moved to alt status. We think they may be sequestered to further kind of protect the process. Certainly, we are glad to be in that courtroom. We hope that the court understands the importance of doing this, despite the defense counsel's arguments, who from the beginning didn't want us in there. We get that as well. And the beautiful thing is we all get to express that opinion, because that's a little freedom of the press and a free speech issue. So we're glad you could join us for this case and the other two that we're following. So stay right where you are. Rosenbaum, who knows what's going to happen next in that case. I'm Michael Bryant. This is the Law and Crime Network. We will be right back. And welcome back to the Law and Crime Network, everybody. I'm Michael Bryant. We are still in verdict watch in the case of Georgia versus Jennifer and Joseph Rosenbaum, but a bit of a wrinkle in that verdict watch. They had been at it almost 17 hours, counting some time this morning, when the judge replaced one of the jurors, took a juror off the panel, put him in alternate status, and put an alt in with the main panel. Why? Because of that contact we heard about yesterday between this juror and an Atlanta Journal-Constitution reporter. The defense renewed their mistrial motion this morning. It was denied, but the judge decided maybe the best way to fix this is remove that juror from the mix. Here's the big bombshell, though, if you're on that jury. Remember that 16, 17 hours you worked on? Forget it. You're starting over with this new alternate in place. And that's where they are. There is still the possibility of sequestration in this case as well. And not to lose sight of why we're here, that little girl, 2-year-old Layla Marie Daniel and her sister Millie, and the 49 counts that are alleged against Jennifer and Joseph Rosenbaum for the ultimate death of Layla and the injury to the sister Millie. So we will keep you posted as this case further develops and the new reconstituted jury begins their work.